but first I'll introduce them. We have AJ Willis, a former member of the Drexel trial team, a graduate of the Drexel program, and now a lawyer in Philadelphia. We have Thomas Azari, a former national champion and All-American from UMBC, now the head coach of the UMBC team that just competed nationals. We have Peter Gaynor, an accomplished trial competitor in law school, an award-winning competitor at Drexel, about to be a practicing lawyer, and of course, an All-American from Maryland undergrad. And your presiding judge today will be Bill Schreier, former United States attorney, and now the head coach of one of the top high school mock trial teams in the country, Carmel in California. I'll turn it over to Judge Schreier. Everybody, good luck.
Thank you, Justin. Good morning, everyone. I'm going to call the case of Lee versus Wax, and I'll ask for appearances, please, from counsel.
Yes, Your Honor. Good morning. My name is Nicholas Wesley, and I represent the plaintiff in this case, Barbara and Avery Lee, who are suing the defendant, Dr. Sam Wax, for negligence on behalf of their daughter, Charlotte Lee.
Good morning, Mr. Wesley.
Good morning, Your Honor. My name is Sierra Jackson, and I represent the defendant in today's case, Dr. Sam Wax.
Ms. Jackson. So I want to make sure that the jurors have their ballots and are ready to proceed before we move into the trial. I'm also going to ask both counsel, if you see anything go sideways, please bring it to my attention so that we can have smooth proceedings. And I understand that there are no preliminary matters to deal with. Is that correct?
That is correct,
Yes.
Your Honor.
Okay, so can the jurors in some way let me know that they're ready to go forward?
A small issue on my end. I'm not seeing Sierra's name on my ballot.
Yeah,
On the defense.
I have the same issue as well.
looks like the defense lawyer drop-down menu is keyed to the same list as the plaintiff lawyers. I just have the same list twice.
We'll fix that, and you can get started. We'll just have that reloaded in 5 minutes. Go ahead.
Awesome.
Okay, great. All right, well, with that, I'm going to assume that everything else is okay for the jury. And there's no motions in limine or anything before this trial. Is that correct?
That is correct, Your Honor.
Okay, then the next order of business ought to be opening statements.
Yes, Your Honor. And just for the record, I'm going to be screen sharing what's pre-admitted into evidence pursuant to stipulation as Exhibit 3 during my statement.
Okay, so Exhibit 3 is pre-admitted.
Yes, Your Honor.
Whenever you're ready.
Thank you, Your Honor. The time, the tug, the trauma. It's January 2nd, 2019. A mother is lying in a hospital bed. A mother to be. Her baby is just moments away from delivery and she's ready. Ready to have a healthy baby. Ready to deliver her child safely. Then just like that, her baby's arm is paralyzed. Why? Today you'll learn that this defendant failed to deliver that child safely. Instead of using as much time as possible to deliver that baby, you'll learn this defendant rushed this delivery. Instead of giving that mother a gentle birth, this defendant tugged that baby out of her mother. Instead of giving that baby a normal life, this defendant gave that baby nothing but trauma for life. The time, the tug, the trauma. That's why we're here today. As the plaintiff, we've sued the defendant for negligence. That means we have the burden of proof. We have to prove to you that first, this defendant owed a duty of care to that baby, Charlotte Lee. And second, that this defendant breached that duty of care, and that in doing so, this defendant failed to act reasonably and caused harm to that baby Charlotte. All that means is that we have to prove to you that this defendant didn't do what any reasonable doctor would do in the delivery of that baby. And that's what caused, at least in part, Charlotte Lee to be paralyzed in her arm. We have to prove that to you by a preponderance of the evidence. Just means more likely than not. Members of the jury, we will meet our burden today. And to prove this to you, we're going to ask you to focus on 3 simple facts: the time, the tug, and the trauma. So first, the time. Today, you'll learn that this defendant had 5 minutes to deliver that child to prevent her death, all because of a condition the mother had during her childbirth. It's called shoulder dystocia. Her baby was stuck in her pelvis. That's when you'll learn that this defendant failed to act reasonably, delivering that baby in only 60 seconds. Members of the jury, you'll learn that there is only one reasonable explanation for why a baby is paralyzed after 60 seconds. A tug. Today, you'll hear testimony from the father of that baby who saw that delivery happen. You'll learn how this father saw the defendant stand up at that operating table, grab that baby, and tuck that baby out of his wife. A tug that no reasonable doctor would do in her shoes. A tug that didn't just leave a bruise. A tug that caused nothing but trauma. You'll hear from Charlotte's current doctor, Dr. Natalie Garson. She'll tell you about that trauma and how for 5 years this little girl hasn't been able to move, let alone even feel her arm. She'll walk you through the evidence that showed that this wasn't just an average soft push and pull delivery. No. What was the only reasonable explanation for that harm? The trauma caused by this defendant when she tugged too hard and too fast. Members of the jury, throughout the course of today's trial, it will be clear that this defendant failed to exercise reasonable care when this baby's life was on the line. Instead of safely taking that baby out, this defendant took the easy way out. That's why at the end of today's trial, I'm going to come before you and ask you to look at the time, the tug, and the trauma. Find this defendant liable. Thank you.
Thank you, Mr. Wesley. Ms. Jackson?
Yes, Your Honor. May it please the court. The risks were rare, but the actions were reasonable. On January 2nd, 2019, Dr. Wax is scrubbing in for a late night delivery, just as she always does. She walks into the delivery room and coaches the mother of this baby, just as she always does. And she guides a new life with her hands, just as she always does. Until everything stops. The baby stops moving. This whole pregnancy is halted by a complication that Dr. Wax has only seen a handful of times within her career. It was a rare risk. But Dr. Wax, she kept her cool. She remained calm. She followed procedure just as she always does. And she delivered a beautiful baby girl with a rare complication. But Dr. Wax used reasonable actions in order to save that baby's life. Now, today, the plaintiff has just come up and told you Charlotte Lee's story, but they didn't tell you the story of Dr. Sam Wax. She's a renowned obstetrician. She has decades of work within her field, full of accolades and praises. She has worked and delivered thousands of babies, and she knows her field like the back of her hand. And she protects the lives of every baby she delivers, just as they're her own, just as she did with Charlotte Lee. But what you'll hear today, ladies and gentlemen of the jury, is that there was a rare complication. And you'll hear that she took every step she could to save Charlotte Lee's life. Now, today, the plaintiff has a burden in this case. As the defense, we don't have one. We can envision this burden as a scale. The plaintiff has to prove to you three things, more likely than not. First, they have to prove to you that Dr. Wax did not respond as a reasonable person would in this situation, in the harm to Charlotte Lee. Second, they have to prove to you without this negligence that that harm would have not been suffered. And third, they have to prove to you that this harm was a foreseeable result. Now back to that scale. The plaintiff has to prove to you, more likely than not, that all three of these things happened. Now, if you see that this scale is tipping in favor of the defense, well, they haven't met their burden. If that scale is even, they haven't met their burden. In order to meet that burden, the plaintiff is going to have to skip that scale in their favor. And they won't be able to do that today. Because they won't be able to prove that Dr. Wax acted unreasonably. They won't be able to prove that her actions caused the harm to Charlotte Lee. Because what you'll hear today is that Charlotte Lee and her mother were at risk for something called shoulder dystocia. The very same complications that happened on that day. The very same complications that may as well have caused the harm to Charlotte Lee. You'll hear today that there are a number of medical maneuvers that a doctor can use in this situation. And Dr. Wax herself will get on the stand and tell you about those maneuvers. She'll tell you about the risks that were involved in this pregnancy. And she'll tell you how she took every step to try and save that child's life. Now, at the end of this trial, I'll get back up. I'll ask you to see whether or not that scale is tipping in favor of the plaintiff. And I'm sure with the evidence you'll see today, it won't be. Members of the jury, remember, it was a rare risk, but Dr. Wax took reasonable action. And that's why at the end of today's trial, I'll come back up here and ask you to find Dr. Wax not liable. Thank you.
Thank you, Ms. Jackson. give the jurors 15 seconds to complete their ballots. Okay, Mr. Wesley, you may call your first witness. I assume that all witnesses are constructively sworn?
Yes, Your Honor, they're pre-sworn.
Okay.
The plaintiff calls Dr. Natalie Garson to the stand. May I proceed, Your Honor?
You may.
Good morning, ma'am. Could you please introduce yourself to the members of the jury?
Good morning. My name is Dr. Natalie Garson.
What do you do for a living, Dr. Garson?
Well, I'm an OBGYN, so I specialize in pregnancy, childbirth, as well as the female reproductive care.
Can you tell the jury about your background and education?
Of course. So I received my medical degree from Cornell University. I'm published on the topics of childbirth as well as shoulder dystocia, which is a childbirth complication. And I've delivered upwards of 500 babies since 2002.
All right, ma'am. Well, directing your attention to this case, how'd you become involved?
Well, I treated Charlotte Lee in 2019, and I was retained as an expert in this case by Charlotte Lee's lawyers.
And would you recognize a picture of Charlotte Lee if you were to see it today?
Of course, yes.
Your Honor, I'm screen sharing what's been pre-marked for identification as Exhibit 4 on the screen. All right, ma'am, what are we looking at here?
That is a photo of the sweet girl, Charlotte Lee.
Does it look to be changed or altered in any way?
No, sir.
Your Honor, plaintiff moves Exhibit 4 into evidence.
Ms. Jackson, 4 has been offered.
And no objections, Your Honor.
4 is received.
Dr. Garson, who is Charlotte Lee?
She's a 5-year-old girl born in 2019. And during her birth, her right arm became permanently paralyzed while her and her mother were under the care of Dr. Sam Wax.
Doctor, when did Charlotte become your patient?
After her paralysis in 2019.
All right, ma'am, you mentioned you were hired to work on this case. What did you do to assess the work in this case?
Well, I conducted a cross-comparative analysis of the documents and evidence of what happened in this case to the relevant medical literature to determine Charlotte's cause of injury and also the steps that Dr. Wax took during the birth of Charlotte Lee.
Did you have sufficient facts and data to come to your conclusions?
I did, yes.
Did you use reliable principles and methods?
Of course.
And did you reliably apply those to the facts in this case?
Yes, I did.
All right, ma'am, before we get to your conclusions, I want to talk about how this childbirth happened. Your Honor, we're about to screen share a timeline to help the jury understand this witness's testimony, and opposing counsel has seen it and reviewed it before trial. All right, ma'am. Based on the materials you reviewed, what time did Dr. Wax arrive at the hospital?
So, according to the delivery note, Dr. Wax arrived to the hospital around 12:10 a.m. And the birth was imminent at that point, once Dr. Wax arrived, but complications arose very shortly after.
Your Honor, I'm reflecting the witness's testimony that Dr. Wax arrives at the hospital at 12:10 a.m. You said there were complications. What complications happened?
The defendant had said that something called shoulder dystocia was occurring.
What's shoulder dystocia?
It's when the baby's shoulder gets stuck on the mother's pubic bone and is not able to easily exit the birth canal, which can be dangerous for both the baby and its mother. And this is what was happening to baby Charlotte.
Well, based on your analysis, what did Dr. Wax do about this complication of shoulder dystocia?
So once Dr. Wax realized that shoulder dystocia was occurring, she asked the nurse to set a timer for 5 minutes. And this timer was set at 12:15 a.m.
Your Honor, I'm reflecting the witness's testimony that a timer was set for 5 minutes at 12:15 a.m. Ma'am, why was this timer set for 5 minutes?
Because when shoulder dystocia occurs, you only have about 5 minutes to act because of the position the baby is in puts quite a bit of pressure on the chest, which poses a risk of asphyxiation or suffocation.
Ma'am, what did the defendant do after this timer was set?
So Dr. Wax had the mother stay in the same birthing position, and she tried to reach in to rotate the baby to get that shoulder unstuck, but that was unsuccessful. And after that unsuccessful attempt, according to Avery Lee, Charlotte's father, who was present during the delivery, Dr. Wax leaned back and made a tugging motion. And then only moments later, Charlotte was delivered.
Now, ma'am, what was Charlotte's official time of birth?
It was just about 60 seconds after that time was set. The delivery note marks her official time of birth at 12:16 a.m.
Your Honor, I'm reflecting the witness's testimony that the time of birth was 60 seconds after 12:15. Ma'am, how many minutes pass from the time of Dr. Wax's arrival to the time of Charlotte Lee's birth?
Only 6 minutes.
And Your Honor, I'm reflecting the witness's testimony that 6 minutes passed between the arrival of Dr. Wax and when Charlotte Lee was born. I'm stopping the screen share. Dr. Garson, what happened after Charlotte Lee's birth?
Well, she was crying excessively and her right arm was moving because she had experienced nerve damage and was paralyzed in her right arm.
Dr. Garson, what was your conclusion in this case?
I concluded that Dr. Wax.
Objection, Your Honor, to 701. May I be heard?
Yes.
Your Honor, although the witness has testified that she had used reliable methods, we've heard nothing about how these methods are reliable within her field or how she reliably applied that method to today's case. It's improper for the jury to hear her conclusion before we hear that.
Your Honor, may I respond?
Please.
Yes, Your Honor. We had to show under Rule 702C that this doctor's conclusion was based on reliable principles and methods. And we already did that. Because whenever I asked this witness what method she used, she talked about a cross-comparative analysis, where she compared the standards in the medical field to the facts at issue in this case. She just spent the entirety of the direct examination talking about what materials she reviewed and how they were compared to the standards in her field. That's enough to show that she reliably applied that method to the facts in this case. And Your Honor, she said that this method was reliable. Therefore, it meets the standard under Rule 702C and D to be admissible.
May I respond, Your Honor?
Yes.
Your Honor, the witness simply said that this was reliable and that it was a reliable method within her field, but she never explained how that's so. They have not fulfilled those prompts.
You know, Ms. Jackson, I agree with you. I remember the beginning part of the examination and thinking that there wasn't elaboration on that. There were just conclusory statements. So I'm going to sustain the objection, but you can attempt to cure the defect, Mr. Wesley.
Yes, Your Honor. Ma'am, could you remind the jury what method you used in your analysis in this case?
Of course. So I used a cross-comparative analysis, which meant that I took the facts and all of the case documents that I reviewed in this case and compared them to my own expertise as a doctor, a published doctor in the topics of childbirth and shoulder dystocia, to also other relevant literature in the medical field on the topics of childbirth and shoulder dystocia.
I just want to be clear for the jury. Has your method been published in the field of medicine?
Of course, yes. This is standard.
And did you reliably apply that to the facts in this case?
I did.
All right, ma'am, what was your conclusion?
I concluded that Dr. Wax's treatment of Charlotte Lee fell below the standard of care that doctors are held to when he tugged on Charlotte to deliver her when her shoulder was stuck on her mother's pubic bone during birth.
Doctor, why did that fall below the standard of care?
Because when a doctor tugs on a baby during delivery, while its shoulder is stuck on that pubic bone in the birth canal, it can cause permanent nerve damage and in turn paralysis, which is exactly what Charlotte Lee suffered in this case.
Thank you, Dr. Garson. Nothing further, Your Honor.
Ms. Jackson?
Yes, Your Honor. Dr. Garson, I want to talk a little bit about that method you mentioned today.
Sure.
Now, you compared the documents in this case to what you've seen in medical literature.
Absolutely, as well as my own literature that I've published.
And you formed your conclusion in using that method?
I did.
But you weren't actually there in the delivery room on January 2nd, 2019.
No, unfortunately, I'm not able to prevent bad things before they happen, which is why I was called to evaluate the situation after it occurred.
Well, you weren't able to see for yourself whether or not Dr. Wax was actually pulling Charlotte Lee.
No, it was the father, Avery Lee, who said he saw the tug.
We'll come to Avery Lee in a bit, but you wouldn't be able to tell us whether or not Dr. Wax used correct medical procedure every step of the way during this delivery.
I was not there to see the delivery, so not with 100% certainty.
But like you said, you did review some documents from people who were in the delivery room that day.
Of course, yes.
One of those being the father of the baby, Avery Lee.
That's right.
Now, Avery Lee says that he saw Dr. Wax pulling.
Yes, Avery Lee said that Dr. Wax had leaned back and tugged the baby, and only moments later, Charlotte was delivered with that right arm paralyzed.
Now, during this time where Avery Lee says he supposedly saw Dr. Wax tugging that baby, he couldn't see her hands, right?
No, he only saw her torso, I believe, because he was holding the hand of the mother.
And the only time he ever saw Dr. Wax's hands was while she was guiding the head out of the birth canal.
That's right, and afterwards.
Now, Avery Lee isn't a doctor.
I don't believe so.
And to your knowledge, he's never delivered a baby.
No.
So he could have confused this yanking or pulling with just normal procedure from Dr. Wang's.
Objection, speculation, Your Honor, under Rule 701.
Your Honor, may I respond?
Please.
Yes, Your Honor. I'm simply asking about the possibility of this being a fact. I'm not asking her to stand in the mindset of Avery Lee whatsoever. I'm simply asking her to tell us if it is a possibility that he could have confused these facts.
Response?
Let me ask Ms. Jackson if who could have confused the facts?
The father, Avery Lee.
Okay, Mr. Wesley.
Yes, Your Honor. The question as phrased of this hypothetical of what this other person would have thought about the situation requires a mindset for this witness to delve into. It's improper under Rule 701, Your Honor. She can't testify to what anybody else could have done in this situation besides the doctor.
May I respond, Your Honor?
Yes.
The way I specifically phrased the question was that it is possible that there could have been a confusion. Again, I'm not asking her to say anything about what Avery Lee was thinking during this situation or what he may have seen or anything as such. Just if there is a possibility that he may have interpreted the movements that Dr. Wax was using as pulling and yanking instead.
And what expertise does this doctor have to make that conclusion?
Your Honor, this doctor has delivered many babies in the past. She understands what happens when she is delivering a baby. However, Avery Lee, who I'm bringing up, is not a doctor. He would not understand. So I'm simply asking her to tell us whether or not, from someone who is untrained, could there be confusion within the situation?
The witness testified or has been deposed or whatever as to what's the exact statement that the witness made? Not this witness, the witness that's being referred to, the father.
The father says that he saw the doctor yank, but he also says that he couldn't see her hands during this time.
I'm going to sustain the objection.
Yes, Your Honor.
Now, Dr. Garson, I want to talk about another deposition that you looked over today for this case. That was Ren Rosenfeld, right?
That's right. Ren was the nurse who was in the delivery room at Charlotte Lee's time of birth.
Right. She was also there.
That's right.
And according to Nurse Rosenfeld, at most, Dr. Wax used gentle traction.
Objection, Your Honor, to hearsay. May it be heard?
Yes.
Yes, Your Honor. Opposing counsel is referring to an out-of-court statement made by Ren Rosenthal, the nurse that was in the operating room, offering their statements to prove the truth of the matter asserted. That this defendant used gentle traction in delivering that baby, it's inadmissible hearsay under Rule 801.
May I respond, Your Honor?
Yes.
The statement that I'm specifically pulling from is from the lawful deposition of the nurse, Ren Rosenfeld. This is not hearsay because it was made during a lawful deposition under Rule 804B.
Your Honor, may it be heard?
Okay, go ahead.
Yes, Your Honor. Opposing counsel needs to lay more foundation regarding this witness's unavailability under Rule 804 in order for this to come in. They need to show under Rule 804A of how this witness was unavailable for their testimony today. Without that foundation, it wouldn't meet the exception to hearsay under Rule 804B1.
Okay, I agree with that without a showing of unavailability. I'm also curious as to whether there's other elements required for this type of statement to come in for its truth. But let me ask a different question. The question that you're asking the doctor is about something that somebody else said?
Yes, Your Honor. It's from the deposition of the nurse who was in the delivery room that day.
What purpose? Why are you asking this doctor that?
Well, the only other people who were in the room were the mother, the father, and the nurse. And we've already covered the father and what he saw that day. Now we're covering the nurse and what she testifies she saw that day.
Mr. Wesley, why is this different than the father's statement?
Yes, Your Honor, because the father is the plaintiff in this case, and that would fall under the party opponent rule. Therefore, it wouldn't be considered hearsay. These statements by the nurse are still hearsay.
Got it. All right, I'm going to sustain the objection, but you can lay more foundation.
Yes, Your Honor.
Honor.
Dr. Garson, you reviewed all materials for this case, right?
I did. I reviewed all exhibits and all depositions.
And you're aware that Ren Rosenfeld is not able to testify.
I believe so.
But in her deposition, she did give an account of what happened in the delivery room that day.
She did.
In that deposition, she says at most, Dr. White used gentle traction.
Objection, Your Honor. I would re-raise my hearsay objection.
Your Honor,
yes.
Your Honor, I laid the foundation that the witness is unavailable today. I asked the witness whether or not she reviewed all of the case documents, and she did. And she said she was familiar with the fact that the witness is unable to testify today.
May I respond?
Yes.
Yes, Your Honor. Under Rule 804A, they have to cite a specific number within that rule to show why this witness is unavailable. A blanket statement from a witness just saying that she's not available to testify today would not be sufficient for this to come under that exception to hearsay. We need to hear more foundation from this witness of how this witness's unavailability occurred, and we anticipate they're not going to be able to lay that foundation with this witness.
Who's the declarant? What's the name of the declarant?
The nurse, Ren Ross.
Rosenfeld.
Ren Rosenfeld. Okay. And the question is whether Nurse Rosenfeld is unavailable.
Correct, Your Honor.
And Mr. Wesley, if it's established for purposes of this objection that she is unavailable, or he, is the rest of the exception satisfied as far as you're concerned?
Your Honor, we believe that there is sufficient foundation for 804B, that other part of the exception, because we did have an opportunity to ask that nurse questions.
And so
However,
this turns basically on the unavailability.
correct, Your Honor.
Okay, I have the pretrial order in front of me. And Judge Capizzi signed this on April 12th. Stipulation 12 sub 3, plaintiff deposed Ren Rosenfeld, Exhibit 7's authentic transcript. Rosenfeld moved to Seattle and cannot be located despite the party's best efforts. Does that not satisfy the unavailability requirement?
No, Your Honor, we don't believe that that's sufficient enough to meet that specific requirement of Rule 804A5, because there has to be no reasonable means to access this person just because we weren't able to locate this nurse at the time when they moved. That doesn't mean that there was sufficient foundation, or that there was sufficient basis to not find this witness.
I
Therefore,
don't
we
have
believe we'll meet that
804A in
exception.
front of me. Does somebody have a copy of 804A that they can screen share so I can see exactly how the unavailability element can be satisfied?
I can do that, Your Honor.
All right, thank you.
Just give me one moment.
Did I correctly characterize the stipulation as far as both counsel are concerned?
That's my
Yes, Your
understanding, Your Honor.
Okay.
All right, screen sharing now.
Mr. Wesley, what's your position as to the text of this? Why is stipulation 12 sub 3 not sufficient to meet this?
Yes, Your Honor. First of all, just because we were not able to locate this witness pursuant to that stipulation whenever they moved, that doesn't mean that there were not other reasonable means to procure this declarant and have them in attendance to testify today. Therefore, it wouldn't meet the requirements by preponderance to be an exception to hearsay as an unavailable declarant, Your Honor. Therefore, it's still inadmissible.
Ms. Jackson?
Yes, Your Honor. Pursuant to that stipulation that you read off earlier, she is unable to testify and they are unable to locate her. If there were reasonable measures, then they should have been taken, but they were not, and she's unable to testify.
Yeah, as I look at it, it's a curious stipulation to make if it's not for this purpose. And if there were concerns about it, then the stipulation shouldn't have been entered into. The objection is going to be overruled and the witness may testify. Ms. Jackson, you may proceed.
Yes, Your Honor.
Now I'll ask you one more time, Dr. Garson. The nurse, Ren Rosenfeld, said that at most, Dr. Wax used gentle traction.
That's right. Dr. Rosenfeld had said that Dr. Wax had both hands on the sides of Charlotte Lee's head and pulled using gentle traction, which is essentially a synonym for a pull.
And just to clarify for the jury, gentle traction is allowed to be used in a delivery like this.
It is, but a doctor does have to be quite careful.
Right, but again, she only said at most to use gentle traction.
That is what the nurse said.
So, Dr. Garson, there's not a single person in that delivery room that was there that day that can conclusively tell you that Dr. Wax used excessive traction.
Only the testimony of Alex Lee saying that Dr. Wax leaned back and used that tugging motion that's the evidence that Dr. Wax used excessive traction.
But again, Avery Lee couldn't see her hands.
No, just saw the torso in that motion.
Now I want to talk a little bit about Charlotte.
Sure.
Now, you've been working with Charlotte since 2019, right?
I have, yes.
You've been working specifically with her on her BPP.
Right, which is a disorder called brachial plexus palsy, which means it's the paralysis of that arm.
You've been working with her entire life.
That's true for 5 years now.
Right. You've been working for her for 5 years.
Yes, I've been her doctor.
So for over a quarter of your career, you've worked with Charlotte Lee.
Yeah, that's about right.
And now today you were testifying on behalf of the Lees as well.
Yes, I was hired by plaintiff counsel.
Well, this is your first time ever giving an expert testimony in court, right?
It is, yes.
So your first time ever giving expert testimony in court is for the same family you've worked on for 5 years.
Yes.
Now I want to talk a little bit about your professional background.
Sure.
Now you've been delivering babies for 22 years now?
I have, yes.
And in your time, you've delivered a little over 500 babies.
That sounds about right.
Now, Dr. Wax has been doing the same thing for 34 years now. Isn't that right?
That's right. Dr. Wax is experienced, which is why it's surprising that this happened.
Well, Dr. Wax has delivered thousands of babies.
I'm sure, yeah.
So she has delivered almost triple the amount of children that you have within your career.
I wouldn't be surprised.
No further questions, Your Honor.
Any redirect, Mr. Wesley?
No redirect, Your Honor. We just ask that Dr. Garson is excused.
Thank you for your testimony, Dr. Garson. You're excused.
Thank you.
Give the jurors, actually, no, I guess it's too early to do ballots at this point since both things need to be assessed. So anything further from you, Mr. Wesley?
No, Your Honor. The plaintiff rests our case in chief, and we're ready for the next case.
Well, Ms. Jackson, you may call your first witness.
Yes, Your Honor. The defense calls Dr. Sam Wax to the stand.
Are you ready?
Good morning. Could you please introduce yourself to the court?
Good morning. My name is Dr. Sam Wax.
Well, what do you do for a living, Dr. Sam Wax?
I'm a certified obstetrician and gynecologist.
How long have you been working in that field?
Lordy, this question ages me just a bit, but I graduated from UCLA Medical Center in 1990, and I've been practicing ever since then. So that's over 30 years and a couple thousand babies I've been able to deliver.
Now I want to talk about today's case. How are you involved in this case today?
Today I am being sued for negligence in regards to the delivery of Charlotte Lee.
Well, I want to start with talking about the pregnancy all the way up to that delivery. How was the pregnancy going up until the day of delivery?
Up until the day of delivery, things were mostly fine. There were 2 risk factors I was keeping an eye out for.
Well, what were those risks?
Well, the mother of the child, Barbara Lee, she was obese, and the child, through ultrasounds we were able to see, was a little bit larger than normal. Both of these put them at an increased risk for shoulder dysplasia as well as brachial plexus palsy.
Objection, Your Honor, to a lack of foundation.
Foundation as to what?
Yes, Your Honor. The witness just made an opinion about what the patient and the child were at higher risk for in terms of their medical needs. They haven't laid any foundation for this witness to know why they were at that higher risk, Your Honor. It's a lack of foundation at this point.
Ms. Jackson.
Yes, Your Honor. First of all, the witness is just testifying as the doctor on the case and is able to assess these risks as well. And if I may proffer,
Sure.
the next question that I'm going to ask is why these factors were a risk and how they may have contributed to these conditions.
Mr. Wesley.
Yes, Your Honor, we need those facts on the record first. We need to hear what other facts and data this witness relied on to make that specific opinion that they were at a higher risk for childbirth dangers. They can't just say that they were at a higher risk without providing any basis for it under Rule 602. It's improper.
Okay, that's sustained.
Yes, Your Honor, move to strike.
It's stricken, but you can fix it, Ms. Jackson, if you so desire.
Yes, Your Honor. Now, Dr. Wax, were there any risks with this pregnancy?
Yes, there were potential risks in regards to the mother's weight, as well as the weight of the child itself. You see, whenever we have larger mothers, they tend to be stronger pushers, which can put more pressure on the baby during delivery. And when the baby themselves is bigger, there's less space in the vaginal canal, which also ends up putting more pressure on them. These combined can lead to an increased risk for potential shoulder dysplasia as well as brachial plexus palsy.
And did these risks play a role in the delivery that day?
Yes, during the delivery of Charlotte Lee, they experienced shoulder dystocia as well as brachial plexus palsy.
Objection, Your Honor, to an improper opinion under Rule 702. May I be heard?
Please.
Your Honor, the question as phrased was, did these risks play a role in the childbirth delivery of Charlotte Lee? This witness has not laid any expert foundation in order to say what roles were played in the delivery of that child. She can testify to what she did in that delivery, her actions, and what she thought was best to do, but she can't say whether or not she can determine what played a role in this case. That's for the jury to determine, not this witness.
Your Honor, may I respond?
Yes.
I'm not asking for an expert opinion from this witness whatsoever. I'm just asking if these conditions that she knew were a risk were present in the day of that delivery. If needed, I can rephrase, but I'm not asking for any type of expert opinion.
What was the question you asked, Ms. Jackson?
I asked, did these conditions play a role in the day of the delivery?
Mr. Wesley, final word.
Yes, Your Honor, the question as phrased is improper right now. It calls for this witness to make an expert conclusion, which requires foundation under Rule 702A, B, C, and D. They haven't laid it, Your Honor. It's improper.
Sustained.
Yes, Your Honor, move to strike the witness's response.
If there was one given, it's stricken.
Now, Dr. Wax, did you see these risks occur on the day of the delivery?
Yes, during the delivery, the baby did end up getting caught against the mother's pelvis bone, which is what we refer to as shoulder dystocia. And then once the baby was delivered, she was eventually diagnosed with brachial plexus palsy.
Now, did you inform Mrs. Lee about the risks?
Yes, I did inform her about the potential risks for both shoulder dystocia as well as brachial plexus palsy.
I want to talk a little bit about that shoulder dystocia. Can you explain that for us?
Yes, it can be a little bit difficult to understand, so I did bring a picture to help demonstrate.
Your Honor, let the record reflect that the witness will be showing Exhibit 3, which is stipulated as pre-admitted. Now, Dr. Wax, what is this diagram showing us?
So this diagram is showing what shoulder dystocia looks like. As you can see in this picture, the baby's upper or anterior shoulder is pressed against the mother's pelvic bone. When this happens, the baby is unable to move through the vaginal canal and they get caught during childbirth.
Now, what about that other term you mentioned earlier, brachial plexus palsy?
Yes, brachial plexus palsy. I know it sounds a bit intimidating, so I think it's easiest to break it into its two parts, brachial plexus and palsy. Now, brachial plexus is just a set of nerves that we all have that connect our spine to our arm and our hand. It goes up from the armpit all the way over the shoulder through the neck. And then palsy is a medical term for paralysis or weakness. You put it all together, brachial plexus palsy. It's when your brachial plexus becomes so damaged that one suffers paralysis throughout their arm and hand.
Thank you, Dr. Wax. Now I want to talk about the day of delivery. How did that day start for you?
It started fairly normal initially. I arrived at the hospital at around 12:10 a.m., at which point I began coaching the mother through pushing the child through contractions.
And during this time, did you ever pull on Charlotte Lee?
No, I had my hands against Charlotte's head in order to help guide her out, but the mother was doing the pushing.
So after the head was out, what happened?
Well, after the head was out, the baby stopped moving. I went to examine, I felt around her shoulder and neck, and that is when I determined that she was suffering from shoulder dystocia.
Have you ever encountered shoulder dystocia in your career before?
I have, but it's extremely rare. In the thousands of deliveries I've done, I've only seen it 5 times prior to this incident.
And how were those 5 deliveries?
I was able to successfully deliver all 5 of those babies.
Objection, Your Honor, to improper character evidence under Rule 404. May I be heard?
Sure.
Yes, Your Honor. The witness just referred to some prior occasions where she encountered shoulder dystocia, where she delivered those babies successfully. That's improper character evidence being offered for its propensity to show that because she did things successfully on another occasion, she was more likely to be successful in this case. It's improper character evidence.
Your Honor, may I
Sure.
respond?
Yes.
Yes, Your Honor, we're not eliciting any type of character trait within this testimony. She's simply saying that in encountering this before, she was successful in the past. But we're not using this to show propensity. We're not using this to prove a character trait at all.
May I respond?
Yes.
Your Honor, they're absolutely offering this for a character trait of safety. That because this doctor allegedly did these prior deliveries safely, that she was more likely to be safe and reasonable on this occasion. There is propensity and action and conformity being offered here, and it's improper character evidence, Your Honor.
Why are you offering this, Ms. Jackson?
Well, Dr. Wax was simply testifying to the experiences that she's had in the past and how she has encountered shoulder dystocia before. We're simply using this to show that it is a rare case. Out of thousands of cases, she's only seen it 5 times.
I got that. It seems like it was the follow-on question that caused the objection to come in. Am I right about that, Mr. Wesley?
Yes, Your Honor. The witness's characterization that these were successful.
Okay. I'm going to sustain that. That's stricken.
Yes, Your Honor.
So, Dr. Wax, when you encountered the shoulder dystocia with Charlotte, what steps did you take?
Well, when dealing with shoulder dystocia, there are 5 maneuvers one can use in order to unhook the shoulder from the pelvic bone. One of which is the McRoberts position, which is when you take the mother's legs and you push them back against their chest in order to relieve pressure. I'd already had Barbara in that position. So at that point, I moved on to delivery of the posterior arm.
Well, what does delivery of the posterior arm entail?
Delivery of the posterior arm is where you deliver the arm that is not being blocked by the pelvis. This way, it frees up some space in the vaginal canal, and the other shoulder can smoothly come out.
Was Charlotte delivered after this?
Yes. Once I delivered the posterior arm, nearly immediately, the anterior arm came unhooked as well, and Charlotte was delivered.
And how did Charlotte look upon delivery?
Unfortunately, I fairly quickly noticed that Charlotte's right arm was limp, at which point I ordered that she be examined.
Now, during the entire period after you diagnosed that shoulder dystocia, did you ever once pull on Charlotte Lee?
No, I did not. I followed the 5 maneuvers that I've been taught before, that I've done before. At no point did I feel it was necessary to use traction.
And what are the causes for brachial plexus palsy?
Generally, in my experience, there can be 2 potential causes, that being excessive traction or internal maternal forces.
Well, let's start with excessive traction. Do you believe that the cause of Charlotte Lee's brachial plexi palsy was excessive traction?
No, excessive traction is
Objection, Your
just
Honor, to an improper opinion.
So,
Yes, Your Honor, the question as phrased again was, do you believe that this specific condition was what caused that child's injury? This witness has not laid any expert foundation under Rule 702 to show, to tell this jury that that played a role in this case, Your Honor. Like we mentioned before, this witness hasn't laid any foundation for their expertise in applying a method, if it was reliable in this case. It's improper opinion right now, Your Honor.
Ms. Jackson.
Yes, Your Honor. Dr. Wax isn't making a concrete conclusion. She is simply saying, based on what she experienced and her rationally based perception and her knowledge, that she believes this is not the cause. She's not giving an expert opinion. She will not say that this was most definitely not the cause, and she won't say that the other one was most definitely the cause.
What's the opinion you're asking her for?
I'm just asking her if she thinks that excessive traction, or if she believes that excessive traction was the reason for the brachial plexi palsy.
Final word, Mr. Wesley.
Yes, Your Honor. Again, this is an issue for the jury to determine, not this witness. She can testify to whether or not her actions were reasonable. She thought what she did was safe. She can't say if it played a role in this case.
Does sound like it requires some expertise to give this opinion. Sustained.
Yes, Your Honor.
Dr. Wax, do you believe that you took the best measures in delivering Charlotte Lee?
I do. I was careful and I followed the procedures and maneuvers that are laid out to be handled in a situation like this.
Is there anything else that may have caused her BPP?
As I mentioned, there were
Your Honor,
risk
improper
factors.
opinion.
Your Honor, may I respond?
Yes, please.
Again, she is not giving an expert opinion. She is simply saying, based on her knowledge as a doctor, based on her knowledge as the delivery doctor of Charlotte Lee, these causes that could happen. She has a medical degree. Anybody that has that could come up here and testify to what could have caused this. She is not saying for certain exactly what happened that day, just possibilities.
I think that that's the point, though, isn't it? That it's not a lay witness. Nobody could go in there and observe this and make these conclusions without, as you mentioned, at least a medical degree. And I don't understand you to be offering this testimony as a product of expertise, just observation. So I'm going to sustain the objection.
Yes, Your Honor.
Dr. Wax, did you ever use excessive traction when delivering Charlotte Lee?
No, I didn't use excessive traction or any traction at all.
No further questions, Your Honor.
Wesley, you may inquire.
Yes, Your Honor. Now, if we could get Exhibit 4 up on the screen, it's already in evidence, Your Honor. Just one moment. All right. Dr. Wax, let's start by talking about the trauma that Charlotte Lee has experienced. This is Charlotte Lee, isn't it?
Yes, it is.
When this baby was born, her right arm, it didn't move, did it?
No, it did not. I noticed it immediately, which is why I recommended evaluation.
Her nerves were damaged.
They were.
Her arm was completely paralyzed. Isn't that true?
Yes.
Dr. Wax, you paralyzed this baby girl, didn't you?
No, I did not. In order to do that, I would have needed to use excessive traction, which I didn't throughout labor.
Well, let's talk about the options for this delivery that you had. Because you know, when a baby's shoulder gets stuck, You're supposed to try different maneuvers to get that baby out, right?
I did. I used the first two required, and on the second one, I was successful in unlocking the shoulder.
Well, ma'am, let's talk about what you didn't do in this case, because you didn't press down on Miss Lee's stomach to push that baby's shoulder out, did you?
No, it wasn't necessary. There's no particular order you need to take those steps in. You just go with whatever's successful, and my second maneuver was successful.
Well, I'm not asking about if it's necessary. I'm asking about what you did and didn't do. And you did not push on Miss Lee's stomach to push that baby out, did you?
No, because I'd already unhooked the shoulder.
Well, ma'am, you also didn't reach into the canal to push the shoulder out of the pelvis, did you?
No, because once again, I'd already gotten the shoulder unhooked.
But ma'am, that wasn't my question. I'm asking about what you didn't do. And you did not reach into that canal to push the shoulder out. That's either yes or no.
No, I did not.
Now, ma'am, it's your testimony that you did not tug that baby.
It is my testimony that I did not tug the baby. I didn't use any sort of pulling motion throughout.
You calling Avery Lee a liar?
I think that Avery Lee is an upset parent who's looking for answers. I deal with that a lot in my field. But I think that he misunderstood what he saw.
Upset parent, that's your testimony.
Yes,
All right, you heard the testimony of Dr. Natalie Garson, didn't you?
I did.
You heard how she said that that father saw you deliver his child, right?
Yes.
The father saw you tug that baby out of his wife.
No, I don't believe that's correct. I believe it was clarified that he wasn't able to see my hands throughout that.
But that's a yes to my question. He saw you tug. That's either yes or no.
He said that he saw a tugging motion. Yes.
Now, ma'am, now let's talk about what happened and how much time it took you to deliver that baby. You walked into the delivery room at 12:10 a.m., didn't you?
Yes, I did.
Your patient, Miss Lee, was in labor.
Yes, she'd already been in labor for, I believe, a few hours at that point.
While she was in labor, you thought shoulder dystocia was happening.
Yes.
You told her to stop pushing.
Yes,
You told your nurse to set a timer.
I did.
A timer for 5 minutes.
I did. That's the amount of time that I would have needed to deliver the baby in.
Let's talk about how much time you actually used. Because, again, you were present for the testimony of Miss Garson, weren't you?
I was.
Dr. Garson said after that timer started, it took you 60 seconds to deliver that baby. Isn't that a fact?
Yes, time is critical with shoulder dysplasia.
But that's a yes. 60 seconds.
Yes.
Thank you. Nothing further, Your Honor.
Ms. Jackson, any redirect?
No, Your Honor. I just asked that my witness be allowed to step down.
Thank you for your testimony. Doctor, you may step down. Give the jurors a chance to complete their ballot. Okay, Ms. Jackson, you don't have any other witnesses, do you?
No, Your Honor.
Okay, so you're resting.
Yes.
Looks to me like the jurors are ready to go. Actually, I got one here. Any juror need more time? I'll take that silence as a no, in which case, Mr. Wesley, you may deliver your closing argument.
Yes, Your Honor. The tug, the time, the trauma. When there's a medical emergency, we expect our doctors to keep us safe. When we're in our most vulnerable moments, we rely on professionals, people with experience, to help us, protect us. But for the defendant, instead of using her expertise and experience to protect the most vulnerable population in this case, of baby Charlotte Lee. This defendant just didn't do her job right. She used her time to speed through that delivery. She tugged that baby like it was nothing. She caused Charlotte Lee trauma for life. She cut corners, members of the jury. She acted unreasonably, and those actions caused undeniable harm to that baby. The time, the tug, the trauma. That's why we're here today. As the plaintiff, we've had the burden of proof. We had to prove to you, just by a preponderance of the evidence, just more likely than not, that the defendant was negligent. In order to do this, we had to bring you evidence. Evidence that there was a duty of care owed to that baby, Charlotte Lee. That the defendant breached that duty of care, and in doing so, the defendant caused, at least in part, harm to Charlotte Lee. Now, members of the jury, everybody here today agrees the defendant is a doctor, and they owed Charlotte Lee a duty of care. In addition, no one here today tried to tell you that Charlotte wasn't harmed. So we only had to show you two things. That Dr. Wax breached her duty of care owed to her patients by acting unreasonably. And that breach caused Charlotte Lee's harm, at least in part, because it wouldn't have occurred without the defendant's actions, and that harm was reasonably foreseeable of her actions. And we proved our case today by showing you three simple facts: the time, the tug, and the trauma. So first, let's talk about the time, because you heard from our expert today that this defendant, she gave a botched delivery. She fell below the standard of care, what any reasonable doctor would have done in her shoes. Dr. Gostin took that stand and walked you through how the defendant knew that this patient was experiencing shoulder dystocia. And what did the defendant do as a result of that? What did she do? She panicked. Dr. Wex knew that she had 5 minutes to deliver that baby. But how long was the delivery of that baby, that larger baby, after that timer was set? Not 2 minutes, not 3 minutes, not 4 minutes. Members of the jury, it was 60 seconds. Why? Because this defendant tugged that baby out of her mother. And that brings us to our second point, the tug, and how you know that defendant pulled that baby out of her mother. You see, members of the jury, there's a reason. After only moments that timer was set, that baby's father said he saw the defendant yank that baby out of his wife. There's a reason this baby was crying hysterically from the moment the doctor saw her eyes. The reason was this defendant's actions. And this defendant had the audacity to get up on that stand today and tell you that Avery Lee was an upset parent. Are you kidding me? Blaming this mother and this father, blaming their condition, saying that they were larger people and that she didn't use any traction. Members of the jury, ask yourself, isn't it strange that this defendant claims every single piece of evidence, every single piece of testimony we bring to you today is just wrong or a lie? Isn't it strange that this is coming from the same person whose license is on the line today, basically? Isn't it strange that not a single one of their 1,000 patients opposing counsel was asking questions about took that stand today and told you that they were a good doctor? You didn't hear any of that testimony today. But you do know what you did hear today. You heard how that nurse and that father both knew that only moments after that timer was set, that baby came out of her mother. That tug caused that baby's trauma. That brings us to our last point, members of the jury. The harm that you know this defendant caused. You heard from both witnesses today about the struggle this little girl has had to endure for the past 5 years. On cross-examination, you heard about the multiple ways this defendant could have taken that baby out safely. Did she press down on Miss Lee's stomach to push the baby out safely? No. Did she reach into the canal to get the shoulder out of her pelvis? No. Did she use more than 60 seconds to deliver that baby safely? Absolutely not. Instead of trying any of those alternatives, this defendant, and you know, she tugged that baby out of her mother. Look, members of the jury, Charlotte Lee was hardly a newborn baby. And she was paralyzed by a doctor her mother thought would keep her safe. This baby couldn't ask the defendant to use more time to help her live a normal life. She couldn't stop the defendant from tugging her away from a future of a healthy life. All she got was trauma. That's why we ask you to do what the facts support and the law requires in this case. Find the defendant liable. Thank you.
Mr. Wesley, Ms. Jackson.
Yes, Your Honor. May it please the court. Rare risks, but reasonable actions. Today you heard all throughout trial, over and over again, how Dr. Wax took every appropriate step when it came to treating that shoulder dysphagia. Every single step she took was to make sure that that baby girl, Charlotte Lee, was able to survive that birth. Everything she did during that delivery was to make sure that Barbara Lee and Avery Lee would be able to hold their baby in their hands, would be able to give her a kiss when she came out of the delivery room. Every single step that Dr. Wax took today, it was for the Lees. Now let's talk about what the plaintiff just told. They came up here and told you a story about how they met their birth. They told you to remember 3 things: the time, the tug, and the trauma. Now let's go through those things and how they didn't reach that birth. The time. Dr. Wax had 5 minutes to deliver Charlotte Lee. And as I said earlier, she was cool and calm. And yes, she was able to deliver Charlotte Lee in 60 seconds, but what else did you hear today? You heard that the longer the baby stays stuck there, the risks, they shoot up, they skyrocket. You heard that after using one maneuver that she had learned, the McRoberts position, she went straight in and used the next one. Well, Dr. Wax told you there's no particular order to do these. Dr. Wax told you that it's not a list that you check down. You use the maneuvers until one works, and one did. She popped out that posterior arm. And luckily, Charlotte came right in. Let's talk about the tug. They told you that Avery Lee saw Dr. Wax tugging that child out of Barbara Lee, but that's not really what you heard from the witnesses on stand today. What you heard from Dr. Garson was that Avery Lee couldn't see Dr. Wax's hands. Avery Lee couldn't see what she was doing close up during that time. And he says he might have seen her tug, but he never was up close and was able to see exactly what she was doing. But you did hear that there was one person who could. You heard that there was one person, the nurse in the room, who said that at most, Dr. Wax used gentle traction. So, out of the people in the delivery room, One couldn't see what was happening. The other was giving birth. And the nurse, who says that Dr. Wax did everything wrong. And all she used was gentle traction. And finally, the trauma. Now, this is something the plaintiff and we can agree on. It is absolutely terrible what happened to Charlotte Lee. That harm that she suffered, it will affect her for the rest of her life, but it didn't come about because of the actions of Dr. Wax. It came about because of the risks involved in this situation. It came about because the mother was obese and the child, well, she was much larger than the average baby is. And as Dr. Wax told you, when these two are put together, shoulder dysphagia and brachial plexi palsy, they're high risk. And unfortunately, that is what happened that day. She said she informed Miss Lee of these risks. She said she knew about it before she went in, and she responded accordingly. She did what she needed to do, and she was able to deliver Charlotte Lee. Now let's go back to that burden that the plaintiff has today. They had to prove to you, more likely than not, that Dr. Wax was the cause of the harm suffered by Charlotte Lee. But as I've just told you, they weren't able to do that. They had to prove to you that without that harm, without that negligence, that harm wouldn't have occurred. But again, we see the risks were there from the beginning. And Dr. Wax knew that. And she took every reasonable action to make sure that she could counteract that. In a type of situation like this, her goal is to make sure that baby lives. Her goal is to make sure that her parents get to hold her, get to see her 5th birthday, her 10th birthday. Her goal is to make sure that that baby is breathing by the time it comes out. But risks are not something we can always prevent. Now, these risks were known to Dr. Wax, but the procedure that she used, that was reasonable. And without showing that the actions that Dr. Wax made caused the harm of Charlotte, and without showing that without those actions, that harm wouldn't have been suffered, the plaintiff has nothing. They haven't met that burden today. If you look back at that scale that I had you envision at the beginning of trial, if you look at it now, you can see clearly, members of the jury. It's tipped in our favor. They're nowhere near reaching that burden. Now, members of the jury, in a second, you'll go back in that deliberation room. But before that, the plaintiff will come back up here, and they'll try to tell you one more time that they reached that burden. Despite the fact that Dr. Wax used every reasonable action, despite the fact that Dr. Wax did the maneuver she was taught, despite the fact that the only witness they had on the stand today, their expert witness, has never given an expert witness opinion before, despite the fact that she's only been working, 12 years less than Dr. Wax, despite the fact that Dr. Garson hasn't even come close to the amount of babies that Dr. Wax has delivered. They've given you nothing. They haven't met their burden. Members of the jury, remember what I've told you today. Remember what we've presented. And remember where that scale is at. Find her not liable. Thank you.
Hey, Ms. Jackson, Mr. Wesley.
Yes, Your Honor. May I proceed with rebuttal? Members of the jury, Ms. Jackson just got up here and made a lot of excuses for Dr. Wax. She told you a moment ago, oh, no, it was just a gentle touch. You know, I just felt the baby's head, no traction ever happened. The baby was just paralyzed from a gentle pull. Members of the jury, this is a case about what's more likely than not. That isn't just unlikely. It's absurd. 60-second births with paralyzation don't just happen when a doctor pulls gently. It's when they tug that baby. It's negligence. Find the defendant liable. Thank you.
Thank you, Mr. Wesley. The case is submitted. I will ask the jurors to submit their ballots. And then I'm not sure whether these rules contemplate post-trial feedback.
Yeah, we'll do feedback as soon as we have all the ballots.
Got it.
All right, we have all the ballots, so we'll ask the judges to provide brief feedback.
Mr. Gaynor, your camera was on first. Why don't you start?
Sure thing. You both are very good. I don't want to spend a lot of time on the good because you've all heard it before. I want to focus my comments on cross-examination because I think you can take that and use it in the next round. And I've got one comment for each of you. Nick, you were faced with a choice that a lot of us have as we go through these tournaments. Do I object or do I let it in and cross on it? And I think you had a moment where you objected where it may have been better to let it in and cross on it. And it's the 404 stuff where she said, well, you've done this 5 times before and it was totally safe. If you had let that slide in and then been able to cross and say, you've done this before, all those other times was fine. They didn't have this shoulder problem the next time. Something different happened here. And I think that would have played really well with the style of closing you gave too. I think it would have given you some more ammunition. Those choices are tough to make in the moment, but that's one example. And for Sierra, you had a great cross point, but it got lost in an objection because you framed it as a conclusion. If you frame it as the facts, which the expert can't argue with, because they're not going to give you an opinion or a conclusion you don't want anyway. If you frame it more as you need training to know the difference between tugging and a surgical maneuver. You have that training because you're an obstetrician. The defendant had the training because she's an obstetrician. This parent doesn't have that training. They never were told what's traction versus what's tugging. You make the same point comes across, and you can follow it up with the obstructed view as well. And it doesn't lend itself to an objection because it's just the facts. But you guys are great. I wish the best of luck to whoever's in the next round, and hope to see you guys next year if you're not seniors.
It's Willis.
Great job to both of you. First, Peter, I laughed that you focused on crosses because I actually want to talk about something in directs. Both of you, I thought did a phenomenal job. Both of my comments for both parties is experts in general are kind of a double-edged sword because you need to qualify them, but you also need the important facts for the jury. And sometimes when you have the witness who is a lay witness but could be an expert in another capacity, that line is kind of hard to follow also. So specifically for Mr. Wesley, I appreciate you going through the expert qualifications. Sometimes I think it's better to just kind of rally through it up front. You had a really clean, great PowerPoint that I wanted to focus more on instead of wondering when the qualifications were going to come. Sometimes it's just better to get it out of the way. The jurors know it's done. And I didn't hear you actually qualify them as an expert. And I could have missed that. I did check in the pretrial order if that was already done, but it was something I was looking for. And then for Ms. Jackson, my comment goes mostly to kind of walking that line between are they an expert or are they the lay witness? Here you have a really compelling story. And I think focusing more on that than kind of getting lost in the verbiage of some of the bigger medical terminology. I did love when you pulled in the PowerPoint to kind of clarify, it's not an expert opinion as much as these are the facts right in front of you. So again, both of you did great, and I wish the best of luck to whoever's moving forward.
Mr. Azari.
Hey, everybody. Yeah, good job. I agree with all the comments that were made previously. First things first, Mr. Wesley, you got to do something about the balloons. It's a serious case. You got to do something about the balloons. if you can. It was a little bit distracting, but I didn't hold you against it, obviously, against you because obviously it was a mistake. But yeah, I think like I'll give you guys general comments. I guess you got a cross and you got a direct comment. I'll give you a general one and then something small on directs as well. I would say like because this is Zoom, it's difficult, but I would consider being more mindful and being more purposeful with when you're standing, when you're sitting. I don't know, Nick, it looks like it's not really clear whether you're standing or sitting. You might be just standing the entire time. If there's a way to make your setup different so that there's a clear difference. I mean, I think it's always effective to have you sitting during direct, have there be a little bit more of a personable approach. Standing during pretty much everything else makes sense. But yeah, the other thing I would say, like, because of the microphones, because of the situation that you have, be clearer when you speak. Your enunciation is really important. One of the things that I noticed from both of you was, you were kind of doing that like mock trial-y, like trailing off at the end of your sentence a little bit for emphasis or for like a little bit of a drama push, but that just does not work on Zoom because I just can't hear you. There were some times when like I think I noticed it a lot with like the hooks because like the way you guys say your hook is like both of you kind of had that strategy there. But like it just resulted in me not understanding what you were saying the first time. And then later when you repeated it in your opening or your closing, then I was like, oh, okay, I understand what that is because you're enunciating it clearly in subsequent times. The last thing that I'll say for demos, I just be more like purposeful with them because I think the timeline was fine. It just doesn't make sense for the attorney to be the one doing it. If the witness is able to bring the witness into it, say like, I brought along a timeline, like to show like where things happened. That's easy. I think that's like a super simple thing because attorneys aren't supposed to be the ones doing that. I think it makes more sense for the witness to do it, especially on Zoom. And Ms. Jackson, I think like the like putting that thing up for like one question, maybe make it two, maybe make it three, something a little bit more because it didn't really feel like it made anything different. But yeah, great job altogether.
Thank you. First of all, thank you for allowing me to preside over this. Real honor to do that. And I agree with that thing about they call reactions or gestures or something where there's balloons. And I think Miss Jackson had a thumbs up or something. You can shut that off. You want to shut that off because it also threw both of you off, I thought, when it came up all of a sudden. So that's an easy fix. You both, I think, were asking to respond, and you should have learned pretty early on that I was going to give counsel the chance to respond. So, unless you get cut off and you had something to say or you didn't get the opportunity. One specific thing for Ms. Jackson, your closing said, remember what I've told you today. That's actually not evidence. What you say is not evidence. So I would remember what the evidence showed today, all right, or what we proved. And then Mr. Wesley, I forget which witness it was. Are you calling her a liar? I would avoid that type of, it's just off-putting, and in some cases it can even be objectionable to do that. That's the province of the jury to determine whether someone is true or not, but very strong performances on both sides. And thank you so much. Professor Bernstein, now what?
Now we announce the winner. I want to thank all of our judges for donating their time this Sunday. And without further ado, we will announce the winner in a split decision is Nicholas Wesley. Congratulations, Nicholas. We're going to ask you to stay on the Zoom because we're going to have your opponent for your final round, Katie Volpert from Penn, sign on, and we'll do a coin flip.